Chapter 11. Mediation. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Mediation is one of two primary alternative dispute resolution methods, referred to as ADR. Arbitration is the other. This page introduces you to mediation. Definitions and analogies. We use the definition of mediation for the most part without understanding what it is. The Oxford English Dictionary describes it as intervention in a dispute in order to resolve it. Wikipedia takes it a little further. Mediation is a structured, interactive process where an impartial third party assists disputing parties in resolving conflict through the use of specialized communication and negotiation techniques. Wikipedia is more correct. Mediation is actually an art form where legal expertise meets psychological know-how. Smart cookie tip. Mediation is sometimes misspelled as medication, intended to alleviate medical problems, and sometimes as meditation, intended to achieve a calm state. Such a coincidence that mediation involves using a calm state to alleviate a legal problem. The difference between ADR's mediation and arbitration. The biggest differences between the two processes are: mediation is a cooperative process, a settlement prelude to arbitration or one's day in court. It results in an enforceable settlement agreement if successful. Arbitration is an adversarial process that results in a judgment. It replaces the court system. Mediation is empowering. Arbitration is adversarial. The evolution of mediation. Mediation among agreeing parties is unconventional in its departure from the centuries-old rival scenario characterizing our legal process. It's a modern collaborative way of finding legal solution through facilitated meetings at the negotiation table. It completely discards the warlike practices of our traditional court system. The predecessor to mediation was the settlement conference in court proceedings, which immediately precedes trial. The process we are talking about here is mediation at the front end of a civil dispute, where the skilled mediator experienced in the trenches of court battles facilitates a multi-stage negotiation intended to produce resolve long before adversarial tactics take hold. Mediation of civil disputes was not popular until mid-1970. But to some litigants it is still unknown, and often the litigation attorneys they hire are more interested in battle than settlement, so it is not mentioned. Mediation's legal pioneers were not trained until the mid-1980s. The American Arbitration Association was the first nationwide mediation trainer. Today's mediation training involves psychological principles, perhaps even more than legal principles. The mediator skilled in facilitation makes all the difference. The combination of a masterful mediator, willing parties, and a no-fault attitude has popularized mediation and made it the cutting edge for resolving legal disputes with a minimum investment of time, energy, and money. Mediation has an 85% success rate. The trained mediator may be the facilitator or even the creator of the solution, but it is only with the parties' agreement that a successful settlement can be reached. Often these days, parties choose to mediate long before their dispute reaches formal adversarial proceedings. Timing is everything. Timing is everything with mediation. In civil court proceedings, the settlement conference typically takes place only after the parties have been involved in years of expensive and grueling litigation. Most often it fails to produce resolve because it comes too late in the game. At this late date, a resolution is improbable. There's too much blood on the litigation battlefield in the House of Horrors, aka the upper civil courts. The litigation frenzy has taken hold. The parties have each spent so much time and money, they can't recoup their loss through settlement. Emotions reign, egos are high, and rigid legal positions rule. It's too late for compromise. Nobody can realistically budge. It's on to battle as each intends to be the grand victor. When ADR came on the scene, it took a good hard look at resolving cases early, even before the cases were filed in the court system. Mediation was created to meet this need. It became apparent that for settlement negotiations to have the very best chance of success, they must come before the battle begins. Although it took a while, the public courts too recognized the value of mediation. Now the civil courts nationwide send litigants to mediation about 120 days after the case is filed, hoping to ease the serious backlog of cases. This is a step in the right direction, but when the parties have already postured themselves adversely and often hired attorneys trained in the litigation frenzy, the success rate is far lower than the 85% achieved if the parties come to mediation voluntarily before litigation begins. The secret behind mediation's success and how it can be your best legal aid. Mediation's success is due to the ideal combination of cooperative efforts between disagreeing parties with the skillful facilitation of a mediator. It's a powerful recipe that brings power to the people with the glue and reality check the mediator provides. Most participants have failed to find resolution on their own, and some have experienced the stark reality of the court system to find that bringing a mediator on board made all the difference. These forces present a strategic about-face where warring parties lay down their armor in favor of peaceful negotiation. They understand what lies ahead and just need a skillful push and a few mediator-crafted horror stories to provide the impetus to find a middle ground. Incredibly, they do. Instead of an impersonal court system deciding your fate, you are in charge. Mediation is empowering. Because of its reputation for empowering people to achieve quick, lasting solutions, mediation is referred to as the holistic legal approach. A ticket to ADR is required for entry. You enter the door of mediation or arbitration with an agreement signed by you and your adversary. These private, out-of-court platforms are not like the court system where anyone can file a lawsuit without the consent of their adversary. Therefore, mediation and arbitration are called alternative dispute resolution (ADR) procedures. They are alternatives to the courts. Everyone who enters ADR is voluntarily agreeing to utilize a more efficient system to resolve their dispute. Mediation is a cooperative process while arbitration is somewhat adversarial but nothing like the House of Horrors. Most parties that go to mediation have agreed they will proceed to arbitration for a binding result if their dispute fails to resolve in mediation. They decide that keeping their dispute out of court is to their advantage. Mediation's companion, arbitration. The companion to mediation is arbitration. We call mediation and arbitration companions because they are the perfect team for a quick, effective legal solution. Mediation is the settlement step, while arbitration is the final determination. Getting to mediation. You come to mediation in one of two ways: as a lawsuit participant routed there by the court, or by a written agreement between you and your adversary, which can be signed before or after the dispute begins. Many of the modern consumer contracts include mediation-arbitration provisions, that if a dispute follows, it will be resolved by mediation followed by arbitration if it fails to resolve. If you and your adversary have a written agreement to mediate, mediation is your initial forum. You are not entitled to access arbitration or the court system, unless small claims is your forum and your agreement excludes small claims matters from your mediation provision, until mediation concludes. If there is no written mediation agreement between you and your opponent, you do not have to mediate before seeking legal redress. Smart cookie tip. You would be wise to do so since mediation has such a high success rate. Confidentiality of the process. One of the secrets to mediation success is its confidentiality. Each party signs a confidentiality agreement. You can admit to a wrong in mediation and deny it later. Not that you want to do that, but all your options before mediation remain intact. Whichever method brings you to mediation, the goal is always the same: to find a rapid, effective resolution of your legal issue. Participants are aware of the pitfalls of litigation. If not, the mediator will share some horror stories, and are motivated by that knowledge. They want to get past the conflict. They want to be in charge and make the decisions themselves. They want results now. Mediation serves that purpose. It's quick, and the parties make their own decisions with the mediator's skilled guidance. The mediator's skillful role. A masterful mediator is able to bring about a settlement through skilled applications of reasoning, analysis, and exploration of options. This occurs through the mediator's mindful application of reframing and releasing techniques. The mediator's role is best described as that of a legal therapist or theorist. The mediator is usually a lawyer or retired judge experienced in the field of your dispute and trained in principles of psychological intervention. Because mediation's sole purpose is to settle your dispute, the trained mediator stimulates negotiation and facilitates you and your foes to reach your settlement. The process is an optimum blend of legal and psychological process. It's far less charged than one-on-one negotiation by utilizing the mediator as an intermediary and buffer. There's no direct contact without the presence of the mediator. All negotiations are undertaken with the mediator, who serves neutrally for all parties but effectively passes information back and forth in an atmosphere of conciliation. The mediator's task is to encourage the parties to express their point of view, then carefully move them past the conflict to settlement. The purpose is not to change opinions or blame participants. No one is ever proven wrong in the mediation process. There is no finger pointing. Instead, differing points of view are acknowledged and validated. Mediation is, in fact, a true behavioral process. The answer in mediation is to acknowledge each party's point of view and find a mutually agreeable way to close the chapter. As long as we are human, we will always have differences of opinion. They are not right or wrong. They are opinions. Resolution does not come about because opinions change. Because of the psychological intervention inherent in the process, mediation does not work without qualified mediator participation. Amid conflict, we're unable to achieve the arm's-length, objective attitude required for resolution. If you follow the recommendations of our settlement chapter before reaching formal mediation, you've exhausted your own conflict-resolving tools. Now, you need the mediator to break the logjam. Addressing the needs of the parties. Mediation also achieves its role as the cutting edge for solution because it targets and attempts to meet the complaining party's needs. One of the most important roles of the mediator is to discover the unique needs of the parties and tailor creative ways to meet those needs. Yes, the mediation process considers the case facts and applicable law, but success comes when the parties' needs are met. Once the underlying emotion is gone, the parties can see what they need to solve this dispute. Getting to the parties' needs means getting them past their sentiments. Usually, participants can't describe their important needs if they are entrenched in emotion. For example, feeling like a victim continually blocks any objective view. So, if there is still strong emotion about the matter, the mediator's goal is to assist the emotional party through and past this state of mind. The mediator accomplishes this by separately caucusing with the stuck party to diffuse emotion, guiding them one-on-one through a series of psychological steps. In some disputes, the only way to truly release the emotion is to get the disputing parties together with careful facilitation from the mediator. Therefore, the mediator must be well trained in psychological principles. Once the underlying emotion is gone, the parties can objectively see what they need to solve this dispute. It feels as if a curtain has lifted, and this is where the real work begins. The mediator discovers what the injured party wants, then researches how the responding party may fill this goal. It may not take the same form as the injured party wants, but it will still work. Smart cookie tip. Creative packaging of settlements can be more fun than a day at the granddaddy of all estate sales. Avoiding court litigation. There's nothing like a horror story to motivate you to consider the alternatives. These days, horror stories abound of the unexpected results received from Lady Justice in the House of Horrors. People are beginning to realize that when it comes to the law, there is no absolute right or wrong. The truth is that nothing is exact in a system set up to evaluate and judge human conduct. Litigants have learned that Lady Justice and the finely balanced scales have little to do with the litigation process. Symbols of law such as Lady Justice and the balanced scales lead people to believe our court system balances truth, justice, and the American way. This statement is true, in part. The court system does mete out justice, but justice is about as vague as truth. Everyone has a different definition. Because litigants now recognize these imperfections, they are willing to balance out their own results in mediation. Why mediate if I'm right? People sometimes come to mediation with the stance, but I'm right and he's wrong. Why should I compromise? The skilled mediator heads off this impediment at the pass. Why should you compromise? Because you don't want to spend your nest egg proving you're right, especially in a system where there is no absolute right. You don't want to carry this dispute around with you for years like a heavy coat until the court system's alarm finally sounds for your courtroom battle to begin. You have better things to do. The case for right and wrong gets lost in the litigation shuffle, whereas the case for mediation is a powerful one. At mediation, everyone is a winner by choosing to focus on resolving their dispute. If you participate in the right and wrong game, you will find plenty of players. You present an argument and so does your foe. Everyone has a reason for being right. Generally, your foe will have an argument just as compelling as yours. Before a judge or a jury, or even before an arbitrator, these arguments might carry equal weight. Or they might not. It's a gamble. You're in mediation because you are not willing to risk such an undefined territory, right? Right and wrong have no place in mediation. In fact, gaming tactics have no place at the mediation bargaining table. Mediation never judges, and never determines winners and losers. There is one objective: to resolve your dispute no matter what it takes. The weapons and tricks of the litigation arsenal just don't apply. Mediation opposition. Informed contemporary folks are in favor of the alternative methods of dispute resolution. As they have become more familiar with mediation, it's their preference. The objections come from attorneys in ivory towers, making a mint from the litigation game of right and wrong. Litigation is a highly lucrative playground. The adversarial litigation frenzy generated by right and wrong in the House of Horrors is expensive, indeed. The frenzy begins with discovery devices and fishing expeditions. Each revelation is met by an investigation of grander proportions. The stacks of documents to be reviewed and analyzed get taller and taller. Issues that once seemed clear and straightforward become convoluted. The more issues are raised, the more your attorney is raking in your savings. It's never too late to mediate. All parties should engage in mediation before moving forward with their dispute. It's not really the attorney's fault. Litigation combat is tough. It takes a lot of work and staying power. And you did hire counsel to wage your war. That's exactly what litigation attorneys do. At the same time, these attorneys make a very good wage in the litigation pit. Some of these litigators are hesitant to give up that income in favor of ADR, which they see as a serious threat to their lifestyles. Leaving the pit in favor of mediation is like changing careers. It takes a strong dose of humanistic motivation for the litigation lawyer to cross the bridge to mediation peacemaking. If you meet with counsel who opposes or objects to mediation, or even arbitration, remember you are the boss. Which route to travel is entirely your decision. You may find that attorneys who also serve as mediators and arbitrators are the best choice to represent or advise you. Why does mediation work when other processes fail? Mediation succeeds because the parties are motivated. They arrive empowered to reach their own solutions. By choosing to mediate, they now take the reins. These parties gather with a single intent: to settle their dispute. They are in the ideal state of mind and have hired a professional to help them close the chapter. With the assistance of the mediator, these parties create an optimum success rate. Mediation participants want to find a quick, effective resolution to their legal issues. The secret to the success of mediation is that it permits the parties to control their own destiny. For this reason and this reason alone, we find mediation produces a degree of resolve that is never achieved when a third party makes the decision. It makes no difference whether a judge, jury, or arbitrator has pronounced the winner. When someone else makes the decision, there is never a deeply felt resolve. It is only when the disputants themselves decide to resolve the dispute that they get a feeling of satisfaction and completion. The mediation settler, though perhaps not receiving everything wanted, feels relieved and successful. Empowered by the contributions she made to the settlement solution, she realizes it could not have occurred without her. There is little recovering to do since the dispute has not been going on long. There was no litigation frenzy, no unreasonable expenditures of money, time, and energy. It's clear that mediation brings emotional and legal resolve. Litigation produces only legal resolve. Recovery for the winning litigation survivor usually takes a long time and is never complete. When comparing people walking away from mediated settlements with winners coming out of court, the parties who have settled at mediation are in a far better place. Recovery for the winning litigation survivor usually takes a long time and is never complete. She may have won, but it doesn't feel as if she brought it about. She feels disempowered because the court or the arbitrator made the decisions in the case. Until the moment of the verdict, she knew it could go either way. For these reasons, she doesn't feel victorious. Litigation takes its toll. The win comes up short. All the time, money, and energy spent along the way can't be restored. Setting the stage. What's so good about mediation is that you can hand-tailor the process, something you cannot do with court proceedings. It's your dispute outside of the rigid court system in the land of all things possible. If you already have a mediation agreement, you can supplement it with customized terms if all parties agree in writing. If you are creating your own agreement, you can contour the expenses and procedures to fit the needs of your case, your lifestyle, and your budget. Mediation customization options. Remember to customize your mediation by including the options in your mediation agreement, or if you already have an agreement, attach the options as an addendum. Since you already have an attorney serving as mediator, you may want to agree to self-representation with your adversary. Refer to the preceding chapter on ADR for the wide range of options customization. Online mediation. Before online ADR, known as Online Dispute Resolution, ODR, parties engaged in an exhausting 10-hour day mediating their dispute in person. By the time the mediation process got around to generating resolution options, the parties and the mediator had traveled an often traffic-delayed distance and been confronted with complex ground rules and a litany of formal procedures such as opening statements and defining issues before moving past positions to interests. The fatigue clock often eroded the ability to make decisions and left everyone frustrated, resulting in parties walking away or making hasty decisions just to be done with it. Now that online platforms have been built to accommodate mediation, these archaic methods have given way to a more real-world process. Online mediation is broken out into short segments focusing more on solutions conjured over a combination of video conferences, email and telephone sprinkled over a few days' time. The online platform avoids the decision fatigue inevitable in getting to and from the hearing and meeting in person for an exhausting day or more. This naturally leads to even more practical and durable agreements and reduces mourning after regrets. And the convenience factor is worth its weight in gold. Many new mediation providers have emerged to fill the need for online mediation. Even with in-person mediation, rules have been simplified. They fill the call of the self-represented party who wants to get it over quickly. With the pace of life as it is now, disputing parties no longer want to be detoured into lengthy, expensive mediation hearings that consume full days. They want to get it done conveniently online to get on with their lives. The ADR chapter describes online mediation in detail with a list of its advantages and disadvantages as compared with in-person mediation. Regardless of which platform you choose, the process is the same. When should you mediate? Your new mantra is, "It's never too late to mediate." But even better is, "It's never too early to mediate." At any stage of your legal process, you can engage in mediation as a method of getting past your dispute. You can do it once, or 20 times. Mediation can occur when the dispute first arises or following years of court litigation. Mediation isn't something you consider only once. You might have had an unsuccessful mediation early on. Later, when the legal system has zapped your energy and your nest egg, you should consider mediation again. Smart cookie tip. Consider automated online blind bidding as a supplement to or instead of formal mediation. After you and your foe have had a taste of litigation, each of you may find yourselves far more willing to compromise. If attorney represented, your attorney probably also has a stake in litigation combat, so it is up to you to bring the case back to looking for a peaceful solution. Remember your mantra, "It's never too late to mediate." Even if trial is lurking around the corner, consider mediation. In fact, this is an ideal time for it. Incentives couldn't be higher. Each party faces hefty costs and lawyer deposits, and don't forget, the gavel's final verdict is just around the bend. Court battles entail complexity and a significant investment of time, emotions, and money. Instead of fighting, suppose you could sit down now with your opponent and work out an agreeable, reasonable, and equitable solution to your problem. Mediation in a contract. Have you and your foe previously signed a contract that requires mediation to settle any dispute which might arise? It is becoming more and more common for mediation provisions to be included in contracts encountered in all facets of life. And most contain arbitration provisions where the dispute will be decided in arbitration if mediation fails to produce resolve. Lawsuit Analyzer Copyright will guide you to review any written agreement between you and your adversary. The provision requiring mediation must include the dispute you now have. Carefully review your provision to make sure that the language includes this dispute. Smart cookie tip. Often the provision will state that it relates to any dispute arising out of the subject matter of the agreement, i.e., a real estate sales transaction. If the dispute falls outside of the agreement scope, the mediation provision will not be operative. Let's take a closer look at the many times when mediation might be just the thing to do. Mediation trigger points in cases headed for the upper civil court system. This section deals with cases headed for the upper civil courts, not small claims court. Here are some of the best occasions to detour these disputes into mediation. Basically, any new development in your case should trigger an opportunity for mediation. No settlement after demand letter. Just before the lawsuit is filed. Just after the lawsuit is filed. At the case management conference. When depositions are set, before their expense takes hold. Before or after a deposition. Before or after any discovery is initiated. Before or after a motion is heard. Any case change. Before trial. At trial continuances. After the verdict. No settlement after demand letter. If your initial demand letter recommended in the settlement chapter fails to produce settlement, follow it up with your ADR proposal. Before lawsuit is filed. For the abundant reasons discussed above, mediation has caught on with such high acclaim that many people choose it before they access the upper civil courts. It only makes sense. Why spend the time and money to hire an attorney and file a lawsuit just so the court can send you through the mediation door, as it does in most states? If you succeed with mediation, you've spent litigation fees for no reason. Savvy people are catching on by entering the ADR door before they climb the stairs to the courthouse. Have an about-face with your adversary. Make the attorneys and the courts the enemy instead of your opponent. Your opposing parties are also interested in curbing their losses and should welcome a proposal with a mutual mission statement, saving attorney fees, time, and stress. Prepare a mediation agreement for everyone to sign and send it to your adversaries with the ADR transmittal letter pointing out the savings in time and attorney fees if ADR is agreed to. These legal battles are emotionally and financially draining. Consider the adage, only the attorneys win in litigation. It's true. We'll pay vast amounts of money to our lawyers and must commit precious time and energy to our legal battle. So, let's make one more attempt to resolve this before we take any further steps. If the contract with your adversary contains a provision awarding attorney fees to the winner, point out that there's no guarantee they'll win or even collect if they win. With the court system as it is, the result could end up the other way around, with them paying your attorney fees. An attorney fees provision is always a double-edged sword. If there is no attorney fee provision, emphasize how much these cases cost. Unless the complaining party gives up much of their case value to their attorney with a contingent fee arrangement, they will both have to pay hefty attorney fees for the next few years. Always keep in mind that whoever wins still must actually collect, and you might not have enough assets for them to seize. Do everything you can to get your opponent to agree to a form of alternative dispute resolution and customize the proceedings to benefit all parties. Remember your mantra, it's never too early to mediate. Just after the lawsuit is filed. If you missed taking the steps above before you filed your lawsuit or your adversary did not accept your mediation proposal, you'll be surprised to find how cooperative your adversary becomes after being served with your lawsuit. After the anger subsides, a whole new, more cooperative demeanor often appears. Use it to detour into mediation. At the Case Management Conference. Nationwide, the upper civil courts now refer their own cases out to mediation. This creates a court-ordered about-face for the parties. This is how it works. A case management conference is set early in each case, usually within 3 to 6 months of filing. The intent is to catch your case before the litigation frenzy takes hold. At this conference, the parties must select a form of alternative dispute resolution before they move forward with their court battle. The parties agree to either mediate their dispute, submit it to arbitration, or both. The court cannot force you to arbitrate, but they can force you to mediate, and they do. In most courts, this step is mandatory. These courts block access to the court system until the parties participate in alternative dispute resolution. The timing is important. Unless self-represented, attorneys have been hired, the lawsuit has been filed and responded to, issues have been framed, and the litigation grind has begun. You and your opponent have had a taste of court and attorney fees. Even if the parties were against alternative dispute resolution before, the atmosphere is ideal for a change of heart. In most states, an alternative dispute resolution information package must be served on your defendant along with your lawsuit. This package informs the parties that the courts will not hear the case until ADR methods are pursued and encourages the litigants to utilize out-of-court methods to resolve their disputes from the get-go. Smart Cookie Tip. Here is an alternative dispute resolution information sample package that includes a stipulation to alternate dispute resolution. Also check out California's case management statement. As of this writing, in California the law requiring mediation in civil cases reads as follows. The legislature finds and declares that a. The peaceful resolution of disputes in a fair, timely, appropriate, and cost-effective manner is an essential function of the judicial branch of state government under Article 6 of the California Constitution. b. In the case of many disputes, litigation culminating in a trial is costly, time-consuming, and stressful for the parties involved. Many disputes can be resolved in a fair and equitable manner through less formal processes. C. Alternative processes for reducing the cost, time, and stress of dispute resolution, such as mediation, have been effectively used in California and elsewhere. In appropriate cases, mediation provides parties with a simplified and economical procedure for obtaining prompt and equitable resolution of their disputes and a greater opportunity to participate directly in resolving these disputes. Mediation may also assist to reduce the backlog of cases burdening the judicial system. It is in the public interest for mediation to be encouraged and used where appropriate by the courts. D. Mediation and similar alternative processes can have the greatest benefit for the parties in a civil action when used early before substantial discovery and other litigation costs have been incurred. Where appropriate, participants in disputes should be encouraged to utilize mediation and other alternatives to trial for resolving their differences in the early stages of a civil action. E. As a pilot project in Los Angeles County and in other counties which elect to apply this title, courts should be able to refer cases to appropriate dispute resolution processes such as judicial arbitration and mediation as an alternative to trial, consistent with the party's right to obtain a trial if a dispute is not resolved through an alternative process. F. The purpose of this title is to encourage the use of court-annexed alternative dispute resolution methods. A deposition has just been set. The upcoming expense of depositions presents an optimum settlement opportunity. Your motivating factor: saving money. You'll each spend about a day and $5,000 in the deposition process. $5,000 apiece can get anyone's attention. Perhaps it is time to resolve your case at mediation instead of rehashing your case at deposition. Smart cookie tip: put the deposition on hold until you complete your mediation. With an 85% success rate, the deposition has only a 15% chance of taking place. A deposition was just taken. You or your adversary are sick of answering questions. Or you both are. Who likes being sworn in to tell the truth under the penalty of perjury as your testimony is taken down by the court reporter to be dissected later and used against you? The post-deposition climate is ideal for proposing mediation. After discovery is initiated by either side. Interrogatories, requests for document production or requests for admissions will each involve another $3,000 of attorney time for both sides and quite a lot of the parties' time. Put a hold on these expensive fishing expeditions while you detour into mediation or automated online blind bidding. Before or after a motion is heard. Various motions are made while a case travels through the litigation frenzy. Each motion costs each party about $3,000. Before and after a motion is another ideal time to propose mediation or automated online blind bidding. At any case change. Whenever the picture of your case changes, another unique mediation or automated online blind bidding occasion is at hand. At each of these junctures, make a proposal or at least make a settlement offer. If your proposal is rejected, follow up with a proposal for arbitration. Your opponent may not have selected that forum earlier in your dispute, but now she may jump at the chance to leave the house of horrors behind. Many clients stuck in egotistical points of view respond to settlement suggestions with, "But won't my opponent think my case is weak?" Our answer is, number. Your opponent will think you're smart. Avoiding attorney fees and years of time eaten up by a matter from the past isn't a productive use of time or money. The weak person remains rigidly right, while the wise one proposes solutions. Before trial. Trial preparation is expensive and time-consuming. Depositions that haven't been taken must be scheduled. Often you will need to hire experts. At least a few months before your first trial date, yes, you may have many, before you spend the rest of your nest egg, propose mediation. Most cases receive a court-ordered settlement conference before trial, but these conferences are too close to the trial date and often do not receive enough focused attention. Private mediation out of the court system provides the best forum at the right time. At trial continuances. You can't assume you will go to trial on your first or second or third trial setting. Each continuance provides a prime opportunity to propose mediation and a chance to save on all those trial costs. After the verdict. After trial, appeals and various motions are sometimes brought, which again are ideal times to propose mediation as adversity and legal fees continue to mount. The filing of an appeal is both a bargaining tactic and a key settlement opportunity. Instead of spending another few years and a further bundle of attorney fees rehashing your case, the appellate process presents another ideal opportunity to settle. A short circuit of the appeal process is clearly in everyone's interest, in terms of time, money, and emotion. Mediation can also be set up at this point. You've already tried your case through the court system. You'll have to wait another few years for the appellate court to make its ruling. Mediation is the ideal time out between battles. Again, you may want to present your mediation proposal directly to your adversary. You are the parties most motivated to settle faced with another set of attorney fees and costs for round 2. It's well worth your while to enter the mediation forum now. Hopefully, this chapter has reminded you. Remember your mantra, it's never too late to mediate. But even better is, it's never too early to mediate.